And good morning, Your Honor. May it please the court. This may be the most significant argument of my career because I am making it on behalf of one of the finest people I've ever met in my career. Mary Keating's case proves that even the best of us mess up. The question before this court is, what should we do about it? To what extent does the public need protection from a lawyer who has spent her entire career protecting the public? Was this misconduct out of character or a reflection of her character? In my argument, I will make two key points. The first is to clarify that her singular offense, which violated rules 3.3 and 8.4, did not involve a conflict of interest or trust violations. Second, and most importantly, that substantial mitigating factors mandate leniency in this particular case. The facts of this case are largely undisputed. Keith Wilson's testamentary intent is undisputed. Mary witnessed that testamentary intent less than 2 days before his unexpected death. She was certainly qualified to authenticate the signature of this long-standing client. So while she was competent to testify that he approved a will that bears his signature, the fact remains that it was one signature short. Mary signed the will to preserve the last wishes of a very special client, but she didn't see him sign it, and she shouldn't have signed it herself. We don't deny this misconduct, but it's important that the misconduct be limited to what actually occurred. This was not a case of a conflict of interest. Mary never solicited any gift under Rule 1.8c and never drafted any instrument conveying such a gift. There's no evidence, and petitioner admits this, that respondent requested, encouraged, or otherwise induced Keith Wilson to designate her as a beneficiary of the life insurance policy. And as Judge Sampson expressly found, the policy was purchased without respondent's knowledge. She did not draft, for example, the application for life insurance. And the will did not convey these life insurance proceeds. Quoting Judge Sampson himself, although there was mention of the proceeds of the insurance policy in the decedent's will, the method of conveying those funds was the insurance policy itself. The language that refers to the insurance policy isn't a language of conveyance, it's actually a language of restriction. Paragraph 4.3, which we've written so much about, memorialized Keith's wishes. Rather than conflict with those wishes, Mary felt it important that they be memorialized in writing, restricting the use of the funds to funeral expenses, estate expenses, cash gifts, mortgages, paying those things off. There is reference that after all of those expenses are exhausted, anything left over she'd get to keep. But that wasn't conveyed by the will itself. And in fact, we have to remember this. This is not a case of elder abuse. Keith Wilson was 2 years younger than Mary Keating at the time he died. He was actually thought to be in perfect health. And so this wasn't something where you anticipate someone is about to die and this is the will we're using and so forth. The bottom line is that it was never contemplated that there would necessarily be anything left over in this case. So we don't have a solicitation of a gift under Rule 1.c. We don't have an instrument that conveys any gift. And I should also say that Rule 1.8c does provide an exception for people who are related to the attorney or in a close familial relationship. And I would submit that although they weren't blood relatives, a close familial relationship probably did exist between Keith Wilson and Mary Keating. They both helped each other out in many ways. Mary rarely charged him, didn't charge him for any of the services in connection with the wills that he frequently would change and things of that kind. So this was not a situation in which this was a total stranger. This was a special case. And unfortunately, sometimes these very special cases lead one to think not with their head, but with their heart. In terms of safeguarding the funds, there was no violation of Rule 19-408B or the Rule of Professional Conduct 1.15D. Under Rule 19-408B, we're supposed to deposit funds that we expect to advance on behalf of our client into trust. We're also supposed to deposit funds into trust that belong in part to a client and in part presently or potentially to the attorney. And that's exactly what we have here. Mary treated the funds, the life insurance proceeds, as hybrid funds. As the personal representative, she had a fiduciary duty to follow the restrictions contained in the will that mandated and directed how those funds were to be applied. The Estates and Trust Article, Section 7101, says that the personal representative is indeed bound in that way. And we did believe that the vast amount of these proceeds were going to be exhausted by mortgages and the like. Now, it turned out, unbeknownst to Mary, that just a month before he died, Keith Wilson paid off two $110,000 mortgages on two properties. So that was a surprise that left a larger surplus than would ever have been anticipated. But Judge Sampson found that even though he himself might have said, well, I think that perhaps those were personal funds put into trust, he could understand why Mary would put them and safeguard them into trust. And frankly, if she had come to me for advice, if she had said, well, what should I do with these? My advice would have been, well, put it into trust, because you don't know yet how much you might get in the end, if anything. And certainly those funds are committed under the will to various uses. Bar Counsel charges a violation also of Rule 1.15D, saying that the cash bequests to Mr. Feliciano and Mr. Haynes weren't paid promptly enough, that they were paid several months after Mr. Wilson's demise. But that's not how estates are administered. Now, I've never administered an estate. I'm assuming Bar Counsel hasn't either. But there are a list of priorities when one administers an estate. Estates and Trust Section 8105 lists those priorities. The Register of Wills fees come first, estate expenses from administration, funeral bills, medical bills, all kinds of things. And then last on the list are any bequests. So one does not immediately pay bequests. That's not what happened. What Mary Keating did do after resigning as personal representative was to provide David Allen, her successor, with whatever funds he needed to administer that estate. And that was only months after the demise of Keith Wilson. So I don't believe that there is any violation in terms of holding funds too long. That was never the case in this situation. Even Alan Gibber, who wrote the most respected tome on estate planning, says that, well, you try to shoot for 10 months to distribute all these different bequests, but as a practical matter, that even that is perhaps optimistic in most cases. So,
I'm just a little confused, though. Were these bequests from the estate, the
yes.
$5,000 or $5,000 and $10,000 amounts, or were these gifts that Mr. Wilson essentially asked Ms. Keating to make out of the insurance proceeds outside of the estate?
No, actually, they're specified in the will, Your Honor. They are bequests under the will. And so if the estate did not have enough money after all the various expenses and priorities were taken care of, then it wouldn't have had the funds to make those gifts. I call them gifts, but they were bequests under the will. That's correct. And so I don't believe that there is a trust violation here of any kind. There's certainly no conflict of interest. If anything, Ms. Keating's interests were identical to the wishes of her client, Keith Wilson.
Mr. Kramer,
Yes.
I have a question about the mortgages that were outstanding. You mentioned a dollar amount with respect to the mortgages. I didn't see in the hearing judge's opinion an amount of the mortgages. And I was wondering if that information is in the record or if it just happens to be something you know.
Oh, actually, I think Judge Sampson does. I'll try to put my finger on it during the time that Mr. Hine is arguing, but I think he does mention that they were $110,000 mortgages, but it is in the record. It is in testimony, my client's testimony, and I think there are also references to it in certain of the exhibits.
Right.
So this isn't something that I've just come up with. But what is interesting is, and you know, you have to say that the facts of this case are just, talk about serendipity. But just the month before he passes away, he pays off those mortgages. Now, he doesn't say anything to Mary Keating about it. He in fact maintains, when he approves on February 14th of 2018, 2 days before he died, the terms of the will still references that the funds would be used to pay these mortgages that really didn't exist, but he didn't say, oh, by the way, Mary, I paid those off last month. It doesn't make any mention of it. And Judge Sampson indicates and observes that she didn't inquire about the state of the mortgage. But why would you? If what you're doing is drafting a will, that wouldn't normally come up in that type of conversation unless he were to bring it up, which he evidently did not.
And the mortgage language was added to the 2017 for the first time, the obligation to pay the mortgage.
I think so. It may have actually preceded that, Your Honor. So I can't be absolutely certain as I stand here whether it was also in the 2016 will, but paragraph 4.3 takes its origin much earlier, and I think it might have been in the 2016 will as well. I think because when Mary first discovered that there was even a life insurance policy, because it had been bought about a year before she learned about it. It was in context of discussing the execution of the 2016 will and her drafting of it. So that's where, that's probably the origin of that clause, certainly, but it also may be the first time where mortgage payments are referenced. Of course, if you're Mary Keating, here's a man 2 years younger in perfect health. He has a physical job. You know, he's a foreman, essentially, has an entourage of people working for him, rehabbing houses. He's an active, energetic guy, 2 years younger, and presumably Mary thought in better shape than her. And so this was quite unexpected. So it was quite a shock to Mary. She lost not only a very dear client, but a dear friend who had been, you know, with her for close to 20 years. So this was a very special case and obviously very unusual serendipitous circumstances here. The key question, yes.
I had a quick question about the difference between the 2018 and the 2017 wills. I know there was a $5,000 additional gift in the 2018, which would have reduced the amount that Mary would have received. Can you just fill the court in on the church conveyance? Because it seems like that one of the other differences between the two wills was that the church, the New Southwest Baptist Church, would have received additional assets out of the estate under the 2018 will.
That's correct, Your Honor. In fact, Judge Sampson made a bit of a mistake there. The church would have gotten under the 2018 will the two valuable properties, Lombard and Calhoun Streets, as well as the bank accounts, which were in the six figures. So the church stood to gain tremendously under the 2018 will. The person that does not stand to gain under the 2018 will, and I don't think Bar Counsel disputes it, in fact, they've expressly admitted, was Mary Keating. Mary Keating certainly had no personal interest in the 2018 will being used as opposed to the 2017 will. It's just that she wanted to preserve the last wishes of a client that shockingly passed away. And so, in fact, because of the additional bequest to Gary Feliciano between $5,000 and $10,000, Judge Sampson himself recognized that Mary would actually get $5,000 less of a surplus if there was indeed any surplus left over. So this is not a situation where she stood to gain. And I think it's important that when we consider sanctions in this case, and while I'm not asking this court in any way to condone what happened, we don't condone it. But we have to evaluate each case on its merits, consider the particular facts and circumstances, and render a sanction that's commensurate with the nature and gravity of the violation and the intent with which they're committed. So state of mind, the lawyer's state of mind, this court has recognized as being particularly pivotal. Here, there was no pecuniary motive, no selfish motive. This was a misguided effort to correct a technical error in the execution of a will that Keith Wilson fully approved and by his signature that Mary recognized as authentic, signed in the presence of one witness. The problem is we were one witness short. And in trying to submit that 2018 will, Mary did not in any way, shape, or form stand to benefit. But she did, after a while, make good faith efforts to rectify the mistake. She self-reported it to Bar Counsel. She informed the Orphans Court through counsel for the estate, Terry McAndrews. She cooperated fully with the Office of Bar Counsel. This is an attorney with not only an unblemished record, but an unparalleled record of public service. Someone who even now, facing you, is serving on more committees than I can count, continuing to serve the bar and the public, continuing to run the employment law hotline and serve on various boards. That's character, Your Honor.
I have a question for you,
Yes.
Mr. Krim. I was just the timeline on the will and the self-reporting. I take it she added her signature to the will in late February and then filed it about a month later in the Orphans Court under penalties of perjury.
That is correct, Your Honor.
And then self-reported about 5 months later in August.
Well, it was in August, that's correct. Early August.
And that was after the caveat had been filed on the will?
Correct. After the caveat, before we responded to the caveat, but after the caveat. Now,
And was there testimony about her thinking during that 5 or 6 month period from putting her signature on the will, filing it, and then the caveat and reporting herself?
Well, yes, Your Honor, there was testimony on that. And Mary quite honestly said that she didn't intend to withdraw the will until the caveat proceeding was filed. But what I think is important to understand here is that because, just signing the will itself wouldn't be an offense. If you signed a will and shoved it in a drawer, we wouldn't even be talking right now. But she did file it in order to preserve his wishes, and that's what she intended to do. Now, she could have maintained the charade after the caveat was filed. And frankly, if it's her credibility against that of Robert Masingo trying in self-interest to cancel out a will that he had no part in, my money would be on Mary Keating, but she didn't do that. Unlike some of the cases where many more significant sanctions have been rendered, that's not what Mary chose to do. She chose to come clean. She recognized that she did make a very big mistake and came clean with it and has been honest about it throughout.
Mr. Kramer, in the caveat, did Mr. Masingo raise an issue about the validity of Ms. Keating's signature?
Yes, he did. But one has to remember that, if Mary Keating wanted to adopt an approach such as, say, Mr. Coppola in one of the cases that had been before this court, she could easily have said, well, gotten with Mr. Schilling and said, well, I was there, right? That is not Mary Keating. That is not what she wanted to do. What she wanted to do here was to preserve the wishes of her client. But obviously she didn't think it through, Your Honor, as Judge McDonald asked about what was she thinking. When you make these kind of mistakes, that's a question you often ask yourself, and it's one that I know Mary Keating has throughout. What was I thinking? Well, She was thinking with her heart, not her head in this case. And that's the problem that brings us here. Thank you.
All right, thank you, Mr. Kramer. We will hear again from you a bit down the road. Good morning, Mr. Hine.
Good morning, Your Honor. May it please the court. Contrary to her counsel's portrayal of the respondent's conduct as acting in good faith and wanting to come clean, she acted in an intentionally dishonest manner with knowledge that she was engaged in illegal conduct and subsequently failed to rectify her misconduct until she realized it was about to be exposed. The respondent placed her witness signature on the February 2018 will of Keith Nelson Wilson 3 days after Mr. Wilson's death, and then submitted that will for probate a full month later with her attestation under the penalties of perjury that the will had been properly witnessed by 2 witnesses. The underlying facts regarding that are not disputed and support the hearing judge's conclusions that the respondent violated rules 8.4b, c, and d, and 3.3a1. The respondent has not taken exceptions to these conclusions of law. The respondent's concealment of her fraudulent conduct continued for several months. She did not take remedial action of her own volition, but only did so after the petition to caveat was filed in July 2018, 4 months after she filed the falsely witnessed will and obtained appointment as personal representative of Mr. Wilson's estate. She acknowledges that but for the filing of that caveat petition, she had no intention of withdrawing the falsely witnessed 2018 will, nor did she intend to self-report her misconduct to Bar Counsel. Such conduct, even without the additional issues presented in the petition, supports the petitioner's recommendation of disbarment when analyzed in the context of what we view as comparable conduct, resulting in disbarment in the Coppola case that is cited in our written recommendation. There is, however, additional misconduct here that is the subject of exceptions taken by both sides and that has been addressed by Mr. Kramer in his segment. Regarding the Rule 1.8c exception taken by the respondent, the hearing judge specifically found at page 6 that the respondent's own testimony evidenced that she was aware there may be some level of impropriety in preparing a will that would deliver to her a benefit. There's been description of the client, Mr. Wilson, in this matter as being headstrong, and that was one of the reasons that the respondent followed his desire to include her as beneficiary of the life insurance policy and to incorporate language of the will. The fact is that the respondent needed to be equally headstrong, if not more so, in advising her client that she could not permissibly draft a will containing the language through which she would receive a gift bestowed to her through the proceeds of the life insurance policy. And while it is true that the life insurance money would technically pass to the respondent by virtue of her being named beneficiary, it is clear from the client's testamentary instructions as incorporated into paragraph 4.3 of the will, of the various wills actually, that the respondent drafted for him, that the client wanted the money used to pay 2 legatees, Mr. Haynes and Mr. Feliciano, specific requests in the amounts of $5,000 and $10,000, and also to be used for other estate-related expenses, with the remainder going to the respondent. His intent, as reflected in that paragraph, was to bestow upon Ms. Keating a gift of some, but not all, of the insurance money. We have no way of knowing if the client fully understood the ramifications of transmitting the insurance money to Ms. Keating by naming her as a policy beneficiary, because as is the problem with dealing with an attorney drafting a will in which he or she is named as recipient of a gift, by the time this usually comes to light, the client is deceased.
Mr. Hine,
Yes.
the will didn't convey a gift. And there's no testimony in the record, the designation of the beneficiary and the life insurance form conveyed the gift, and there's no testimony in the record that she was consulted. In fact, there's testimony to the contrary, that she wasn't aware. And what do you make of Mr. Kramer's argument that this is actually, she wouldn't have had to have put any of this language in the document. In fact, if she was looking out in a self-interested way, she would have just retained the life insurance policy and not attempted to commingle it, if you will, with estate assets so that it would be used for estate purposes.
So I'll try to address those points. Part of the problem is that there's an inherent inconsistency in what the respondent argues regarding the Rule 1.15 issue and what is being argued regarding the 1.8 issue. The respondent herself drafted the will containing the language in paragraph 4.3 for her client, and presumably adopted language that reflected his testamentary intent, which, as I'm trying to point out, included the use of the life insurance proceeds to make bequests, to pay bequests to Mr. Haynes and Mr. Feliciano. So while Your Honor is certainly correct that the will itself did not convey the proceeds of the life insurance policy, the respondent drafted the language of the will that contained reference to bequests and other uses of the funds before she was to receive the remainder of the insurance proceeds. So it's our view that the hearing judge correctly concluded that she did draft an instrument by which she received a gift that contained language bestowing upon her a gift, and that under those circumstances, this violated Rule 1.8c, and that the respondent had the obligation, if that was truly what how the client wanted to proceed, to refer him to another attorney to draft that will for him rather. I would note comment 7 to Rule 1.8.
Mr. I have a question. Isn't one way to look at this that by drafting the language in the will in part 4.3, Ms. Keating devised language where she agreed to use money that would have otherwise been hers free and clear as a beneficiary of the life insurance policy? She agreed to use money for the benefit of the estate to pay certain expenses and the mortgages as well, and to make bequests.
Yes, Your Honor, that is a way of looking at it. But again, the respondent was the attorney involved in this process. And therefore, if based upon her private conversations with the client and his explanation as to how he wanted the life insurance money used, the more prudent course of action from our point of view, and we believe the hearing judge so found, was to refer the client to outside counsel. And I was about to refer to the comment 7 to Rule 1.8, referring to the necessity of the client having the detached advice that another attorney can provide under these circumstances.
Would there have been a conflict of interest if Ms. Keating had simply been named as a beneficiary in the life insurance policy and then drafted the will for Mr. Wilson, but the will did not mention the life insurance policy?
Well, I think there would not have been a conflict of interest under Rule 1.8c. And again, there's no evidence that the respondent herself influenced Mr. Wilson's decision to name her as the beneficiary. So under those circumstances, no, Your Honor, I don't believe there would have been that violation. But in fact, Mr. Wilson seemed to want the life insurance money to be used for more than simply having Ms. Keating receive the money as a beneficiary of the policy, and that he gave her specific instructions to use those funds inferentially, at least, as part of his estate although there was no conveyance through the will of the insurance proceeds.
And doesn't 1.8 require a gift, the conveyance of a gift?
Your Honor, yes, that the express language of the rule does use the term gift. A substantial gift has to be received by the client by the attorney through the document.
And it would appear here that there was no such gift through the document to Ms. Keating.
Well, as a matter of law, because she was named as beneficiary, that would be true. But under these circumstances, we're asking the court to look beyond the mere conveyance of the money through the life insurance policy and examine the client's apparent testamentary intent, which was adopted by the respondent herself in the language that she drafted in paragraph 4.3. And that included the use of a portion of those funds, not simply that Ms. Keating would receive all of the insurance money, but that he wanted that money used for purposes that related to his estate, and also to be used to pay out bequests that were identified in previous paragraphs of the will. So under those circumstances, we're arguing that the will did bestow a gift upon the respondent through the life insurance policy, that she drafted an instrument that contained that language bestowing upon her a gift. And
Mr. Hine,
Yes.
isn't that language ineffective? As
Well,
a testamentary intent, isn't it ineffective?
It probably is, Your Honor, yes. And that goes to the issue then of, I guess, crossing over to what happens after the client has passed away and the respondent receives the insurance money. She was free to use it as she saw fit, and the hearing judge specifically found that the life insurance money was her sole property. Therefore, crossing over to the Rule 1.15 issue, having made that factual finding and based upon the conveyance of the money to the respondent personally, such funds should not have been commingled with other client funds in her attorney trust account.
Well, I think in response to Judge Watts, Bar Counsel is attempting to argue two different ways in this case, and it's confusing to the court. The life insurance funds are not estate assets. They're personal funds, and the language in the will basically has no testamentary effect. However, it is language of an intent in the testator that doesn't have legal effect, but it is his wishes that Ms. Keating receive these funds and then use them in a certain way. So Bar Counsel wants to argue they're personal funds on one side, but then continues to call them bequests under the will, which they aren't. There's no testamentary effect under the will.
Your Honor, I agree with you on a certain level, but it's not, I don't believe that it's Bar Counsel necessarily that's attempting to argue this both ways. This is a situation of the respondent's creation. She was the one who drafted the will on behalf of Mr. Wilson, containing the language that incorporated how the life insurance money was to be used.
But my point is, in applying the rules of professional conduct, you can't argue that these are bequests and therefore the funds should go into the trust account. And on the other hand, argue, wait a minute, these are personal funds and she violated the professional rules of trust accounts by putting personal funds into the escrow account.
Well, I will concede on the fact that the funds were considered her personal funds based upon the conveyance by the life insurance policy. I don't necessarily agree or concede that the Rule 1.8C violation then is no longer valid based upon the respondent drafting an instrument that contained language by which she was to receive a portion of the life insurance proceeds after payment of other bequests set forth in that same will. But I don't want to belabor that point too much, and I'll leave that to the court to determine.
Well, let me follow up with one other question. Under the terms of the will, would Mr. Feliciano receive, under the 2018 will, $10,000 as a bequest if there was no life insurance funds to pay that from?
Yes, Your Honor. There is a bequest contained in the will, separate and apart from the instructions on the use of the life insurance money.
Okay.
As I recall, I believe that's correct. So,
Mr. Hine, I
yes,
have a question about your exception to the hearing judge's finding of a lack of dishonest motive. Why have you accepted to that, or why is that incorrect when there seems to be no dispute that Ms. Keating did not benefit as a result of the 2018 will over any result that would have come from the 2017 will?
yes, Your Honor. The exception is the mitigating factor that is referred to involves that the respondent lacked dishonest or selfish motive. And we have tried to isolate the dishonesty component of that factor from the selfish component. We're not arguing that the respondent had any selfish motive or that there would be any further pecuniary gain to her by her action. But we're trying to argue that there was a dishonest motive that can be ascribed to the respondent based upon her conduct in choosing to submit the falsely witnessed 2018 will to for probate, and that she made a conscious choice that was motivated by her desire to see that will submitted for probate as opposed to the validly witnessed will from 2017. And I guess the difficulty is in reconciling the findings of fact and conclusions of law by which she has been found to engage in dishonest and deceitful conduct by falsely witnessing the will and then submitting that will for probate a month later, which clearly involves dishonesty, and then to say that, oh, she lacked dishonest motive as a mitigating factor. That's the argument that we make regarding that mitigating factor. Not that there was a lack of selfish motive, only that there was a lack of dishonest motive. I did want to return briefly
Can I follow up just on Judge Watts's question? Because I was wondering about it too. So is it your position that there can never be a finding of the mitigating factor of absence of dishonest motive when there has been a conclusion of law that there's been an 8.4C violation?
No, Your Honor, I think I've learned over the years never to say never regarding any set of circumstances that may arrive, but under these particular circumstances, we feel that the evidence suggests that there was a dishonest motive based upon the evidence that was found and the actions of the respondent. I can't point to another set of circumstances that I would describe as different where there would be an 8.4C violation, but there still could be a lack of dishonest motive. But under these circumstances, in this specific case, it's our argument that there would be a lack of dishonest motive. I wanted to return briefly to the Rule 1.15 argument. Assuming that the court recognizes the life insurance proceeds payable to the respondent as beneficiary as her personal funds, again, it's our argument that the hearing judge then should have found violations of Rule 1.15b and Rule 19-408 based upon the commingling of those funds. We do not agree with the respondent's argument that the funds had some sort of hybrid nature to them and that they qualified under Rule 19-408b2 as funds belonging in part to a client and in part potentially to the attorney. The money belonged solely to Ms. Keating, to you, as the hearing judge found, and her own conduct with regard to the handling of those funds demonstrates that she believed that she could disperse the funds however and whenever she saw fit. The first distribution she made of the $100,000 was in December of 2018 when she withdrew $10,000 for her own personal use to pay her income taxes. She did not distribute the $15,000 for Mr. Haynes and Mr. Feliciano until the following month, January of 2019. And at that point, she did not make those distributions directly to the two individuals, but paid them to the successor personal representative to be placed in the estate. Based upon
Mr. Hine, at the time that Ms. Keating used money, at the time that she used the money to pay her taxes, wasn't it known that the mortgages had been paid off already?
Yes, Your Honor. It was known that the mortgages were paid off, but the precise amount that was going to be needed to address the other estate expenses remained unclear, and there was no clear accounting of the $100,000 that by which she could say, I'm definitely entitled to $10,000 at this point in time. And that belies her own I'm sorry, go ahead.
Just appears from the history of the language in the document, the mortgages were anticipated, adding the mortgage expense. That was the anticipation that there might not be funds left. That's the time when the document began to include language that she was entitled to the remainder, if any. That was in 2017. Prior to that, the document didn't include the language that she would get the remainder, if any. She was simply entitled to the remainder after paying the expenses and making whatever bequests the document contained. So it would appear that after payment of the mortgages, she could have had a good faith expectation that there would have been $10,000 available for her own personal use.
I believe that's correct, Your Honor. But based on her own argument that there was some hybrid nature to the funds, I don't know how she could make a determination as to what amount she is or is not entitled to until all of the estate-related administration expenses had been determined, and that would be at the conclusion of the administration of the estate, which had not yet even taken place as of the time the hearing in this matter was held in January of this year.
Does the record have any documentation of what those estate expenses turned out to be? Can you tell us what they were?
The record does contain some documentation of expenses that the respondent herself had paid as through the date of the hearing in January. And as of that time, I think she had dispersed $10,000 to herself, $20,000 for payment to Mr. Haynes and Mr. Feliciano, and then an additional $10,000 or so was related to Mr. Wilson's funeral expenses and estate-related expenses. I don't have the precise breakdown, but I know there is documentation in the record of that as one of the petitioner's exhibits. So as of the time in January that the hearing was held, she was still holding $60,000 in her attorney trust account.
And the estate fees had been paid as part of the $10,000 that you mentioned that went to the funeral expenses and the estate expenses?
Yes, Your Honor, I believe that's correct. But that $10,000 was only the estate-related expenses up until that point. Mr. Allen testified that there would be additional expenses, including the necessity of opening an estate in the state of Florida to dispose of real property that Mr. Wilson owned there. And he had not yet even begun that process as of the time the hearing was conducted in January. So that expense remained to be determined, as well as some other expenses.
Does the record reflect that the estate expenses have exceeded or are expected to exceed the $100,000 or the $90,000 after Ms. Keating paid her taxes?
No, Your Honor, I don't believe the record reflects that the amount will exceed the $60,000, although I don't know what the expenses were, and I don't think Mr. Allen knew at the time in his testimony what the expenses were going to be associated with this matter in Florida and whether there would be any complications associated with that. Presumably, those expenses would not exceed the $60,000 that was left in the trust account at that time.
So, Mr. Hine, are you arguing that these are estate funds and that she should not have withdrawn any money from the account until she knew total estate expenses? Or are you arguing these are personal funds and for her to withdraw $10,000 of her own personal money was okay?
To be clear, our primary argument is that the money belonged to the respondent, and therefore she violated the commingling provisions of 1.15b and 19408 when she put the money into an attorney trust account.
But you were just arguing that she shouldn't have spent any of that money or taken out any of that money for personal uses until she knew the total expenses of the estate.
Well, Your Honor, that's part of the alternative argument, and it's based upon the respondent's defense of why she was permitted to commingle funds in her trust account. If the court accepts that the funds belong to her and that she violated the commingling provisions, then there's no reason to even get to the secondary part of the argument that other obligations under Rule 1.15d applied. But this is based because the respondent has argued this way, that the funds had some hybrid purpose and were not solely her personal funds. That's the reason that we're arguing the $10,000 issue, I suppose, that reflects that she was using the funds as she saw fit, regardless of whether, but nevertheless had maintained them in her attorney trust account.
Excuse me, Mr. Hine, I think the respondent is making that argument because it's a response to your exception that the hearing judge failed to find either B or D.
I believe the respondent has been making that argument all along, and that was part of the reason that the hearing judge did not conclude that either provision, any provision of Rule 1.15 was violated. There has been this inherent conflict in the respondent's position that has in turn caused Bar Counsel to have to make alternative arguments. And the respondent is the one who has been seeking to have it both ways, arguing on the one hand that there was no conveyance of the life insurance proceeds through the will because she would be the recipient under law. But then on the other hand, she argues that the funds had a hybrid purpose and that she had to maintain them in her attorney trust account. So the reason that we're making those dual arguments is because of the way the respondent has defended this from the outset.
But I guess it's a little circular because the respondent is making those arguments because of the charging document and the nature of the charges that were filed against her.
Well, I'll accept that could be the reason, but it started as far back as Bar Counsel's investigation that this argument was being made. But I see that my time is about to expire. So in conclusion, I did want to emphasize to the court that Putting aside 1.8 and 1.15, the emphasis in this case should be on the respondent's dishonest and deceitful conduct in violation of the rules that have not been subject of exceptions. And referring back to the Coppola case, the court wrote in that case that the great strength of our profession lies in the integrity with which we act and the honor that we bring to our work. The respondent, in her own testimony before the hearing judge, described Mr. Wilson as a man who really hated dishonesty. She dishonored her deceased client and the legal profession by her dishonest and fraudulent conduct in this case, and the petitioner therefore recommends disbarment. It's consistent with the court's sanction of Mr. Coppola.
Thank you, Mr. Hine. Mr. Kramer.
Thank you, Your Honor. Judge Watts, the 2017 will, you are correct, it's the will that first mentioned in paragraph 4.3 the mortgages, which is actually all the more reason that Mary wouldn't think there'd be anything left over. And that, of course, was the same paragraph that was continued into the 2018 will that we're here to discuss. I should also say that, contrary to what Mr. Hine has told you, Mary Keating didn't allow herself to be a beneficiary of the life insurance policy. I could take out a life insurance policy today and name all of you as beneficiaries. And there isn't a thing that you can do about it. No amount of judicial power could overcome that. I'm sure none of you would really object, but the reality is that you can't object. I get to designate whoever I want. This is a headstrong client who wasn't going back on it, and the testimony is pretty clear on that point. So what is a lawyer to do? Well, a good lawyer will then memorialize the uses for those funds. I should say, in response to one of Judge Getty's questions, that paragraph 4.3 isn't entirely non-binding. It's a term of the will, and it's binding on the personal representative who, under the Estates and Trusts article, does have a duty to adhere to the terms of the will. At least that was Mary's thinking, which is exactly why you put those funds into trust and safeguard them until you know that there is a sufficient surplus available to do other things with it beyond what is specified in the will. And certainly, as Judge Sampson observed, that was a very reasonable conclusion to draw. And until this court comes out with an opinion that says, no, disregard the will, just put it into your own account, otherwise it's commingling, I'm going to continue to advise clients in this situation that when you don't know how much will ultimately come to you versus will go to the uses your client has designated, put the money in trust. Whether you want to call it hybrid funds or otherwise, let's not split hairs. The safest approach is to safeguard the money, put it into trust, and that is exactly what Mary Keating did in this case.
But she also could have opened a brand new personal account just to hold this money and not commingled any of these funds with other client funds, right?
That is true, and then you'd be depriving the Maryland Legal Services Corporation of the interest. Why would we do that? In other words, if she believes as an attorney that her legal obligation, particularly as personal representative, is to commit the funds for various estate purposes, and that some funds may ultimately come to her, but she doesn't yet know how much, that to me falls squarely within a rule that says put it in trust. That is the safest approach. Now, we can talk technicalities all day long as to whether it truly should have been regarded as personal versus estate versus whatever. I think it's both. I mean, I think Bar Counsel is trying to have it both ways, but in reality, it is both. There was some money that was supposed to go to the estate expenses and other obligations as defined in 4.3, but other surplus, if there was any surplus, would be left to the beneficiary of the policy. So I do think that what she did was consistent with what a responsible attorney, responsible professional does do. To Your Honor's point, Judge Moran and Judge Watts talked about dishonest and selfish motives. Bar Counsel wants to create a distinction that this court has not This court doesn't distinguish between a dishonest and selfish motive. When it's come up, this court has used the terms interchangeably. Steinhorn and Stinson are examples of that they would derive from the self-interest that the attorneys had been motivated by as a dishonest or selfish motive. Usually those terms are used together despite the word or. So to draw a distinction would be to eliminate, as Your Honor has observed, that mitigating factor in any case involving any element of dishonesty. I should also point out, and I really want to talk about sanctions because this is really where the rubber meets the road in this case. This court has reprimanded attorneys for misrepresentations in the past. I've counted 26 reprimands, and I put them all in Appendix A by this court or the commission between 2006 and 2019. The court in the Paul case, for example, 2011, found that if the misrepresentation was an isolated episode not likely to recur, and in using that language, it quoted from the Stansel case all the way back to 1983, then perhaps a reprimand is appropriate. There have been other cases, though, where this court has imposed modest suspensions between 45 and 90 days. In Rohrbach, the court imposed a 45-day suspension for a client, for an attorney that let the client use a false name to deceive the court as to the criminal record. In Gordon, 45 days for fabricating a contract. 60 days in Tanco for filing misleading expungement papers. In Maxwell, 90 days, where the attorney did much more than Ms. Keating did, because the attorney wasn't simply correcting a mistake in execution, but actually taking a will that the client never signed or approved and forged the name of that client to it, and also recruited others to lie. Or I'm sorry, that wasn't it. It was in Maxwell, falsely witnessing and notarizing a deed under a fictitious name. So the deed itself was never actually signed by anyone, and it was an imposter's name used. And this court said, look, we can't condone the deliberate falsification of a solemn document by an experienced attorney. But this lawyer had 30 years of exemplary experience and sincere remorse. So the court imposed a 90-day suspension. That was back in 1986. And you might say, well, that's an old case. Why are you bringing up ancient history? It was a very different court back then. Let me tell you why. Because Mr. Maxwell has been a lawyer since October of 1957. He's still an active member of the bar today. And this month will celebrate 63 years as a member in good standing of the Maryland Bar. Did this court's 90-day suspension of the attorney protect the public? He's never been back before this court or the commission since. Mary Keating will never be back before this court, except as perhaps to argue as an advocate, I hope. The fact is that we're dealing with an attorney whose body of work can't be negated by a moment of weakness. Can't negate a whole life of what Judge Berger on the Court of Special Appeals described as a dutiful public servant who has humility, who's worked hard, who's brought honor to this profession. Quite selfishly, just like Judge Berger, I don't want to lose Mary Keating, because wherever this court looks to any public interest function, organization, be it the Women's Bar, president of the MVLS, the Women's Law Center, establishing an employment law hotline because she saw the need for those who are underrepresented. Wherever you look to a big job, you find her name. And we're not talking resume padding. She's taken visible and behind the scenes positions. And she's continuing to serve to this very day. The fact is that I don't want to lose her from this profession. And what I'm asking on behalf of the bar and the public that we are all sworn to protect is that this court impose a sanction which does not unduly disrupt her ability to serve.
And your recommendation would be what then?
No more than a 90-day suspension. I believe, Your Honor, that Maxwell involved more significant misconduct. And Mr. Maxwell, though still a respected criminal defense attorney to this day, clients love him to this day, never had anything close to the record that Mary Keating has amassed in more than 35 years as a member of this bar. This court has rarely had a case. I don't think you've ever had a case with this kind of mitigation. And so I believe that it compels leniency. And that is exactly what I would ask, not only for me and Ms. Keating, but the public as well.